We have serious concerns, a pending CPS investigation, a pending district court case, a no contact order.
Jeremiah has been the father to this child since his birth. He has a strong bond relationship that if the court were to rescind the ex parte order, this minor child would not be in danger.
This Jeremiah fellow does not have standing and
was appropriate at the time. It has now been objected to by Mr. All right, good morning, everyone. Call the next case. This is Abigail Brink and Matthew Strabbing, file 24-19690-DP. Can I have the attorneys state their names for the record, please?
Good morning, Your Honor. Elliot Blumberg on behalf of Abigail Brink, who's appearing via Zoom from my office.
Thank you.
Good morning, Your Honor. Daniel Finling, I'm appearing on behalf of Matthew Strabbing.
All right. This looks like an objection to the court's ex parte order signed April 22nd. Mr. Blumberg, is that your objection?
Yes, Judge, it is. My client was actually only properly served with the ex parte order on May 4th. Mr. Strabbing sent her a picture of it. Not sure that actually accomplished proper service, but be that as it may, we filed a timely objection. The individual who's the affected party by the ex parte order has been out of the household pursuant to the court order. I think it's important that the court understand that Mr. Strabbing has had little or no contact with the child since the child's inception. My client strongly believes that this ex parte order is adversely affecting the minor child who has a strong bond with her significant other. We're certainly going to ask the court, if necessary, to conduct an evidentiary hearing to determine whether or not the ex parte order should continue. I would remind the court you're also the judge in the criminal matter, which is pending in the district court. There are bond conditions that would cover this situation. We think that the court could rescind the ex parte order. There have never been any allegations as between the gentleman and the minor child. So I don't know if you're prepared to rule on our motion today or whether you're simply going to schedule an evidentiary hearing, but we genuinely believe that it's not necessary and inappropriate.
The grounds for the objection were that you were not provided with a copy of the motion or the verified pleadings. Have you been given copies of those things from the court now?
I have received them, but we were more concerned about filing our objection in a timely fashion.
Your Honor, in response, I am newly retained and I have looked over this file. I will note that in reviewing my notes on the file and in my investigation that there is currently a no contact order in place against Mr. Bloomberg's other client who has been charged, understanding, with an abuse petition. That's 87A District Court. I have a case number as well. I'm not sure about the existence of a no contact order, but I can tell you, as we can all agree, that a district court does not have jurisdiction over what's in the best interest of a minor child. That's your job, of course. In terms of service of process, I did review the court rules relied upon by Mr. Bloomberg, but I will also note that the court did serve a copy of the motion on Miss Abigail, and it was returned because she had moved and not update the court with her new address is required under any support order or custody order otherwise. My client's current wife also sent a copy of the motion to Mr. Bloomberg as soon as she became aware that counsel was retained. Now, my client was representing himself in pro per up until just recently when I was retained. Also, my office served a copy of the ex parte order on Plaintiff in this matter on April 23rd, 2026. And a copy of the order and the motion was sent to opposing counsel on both April 23rd and May 1st. Now, There's a procedural objection brought by Mr. Bloomberg as to, I guess, a procedural due process matter of some sort based upon the court rule. However, I don't think, I think he relied on, if I remember correctly, 3.207B in terms of notice. That's been complied with, and the suggestion that a district court is somehow going to provide protection in an ex parte order simply prohibiting the accused, who in which the plaintiff in this matter is currently living at his house, who has a no contact order in place because of abuse of his own child, and suggesting that the district court's order, no contact order, is sufficient, I believe is inappropriate. The ex parte order was properly entered into. Notice and an opportunity to be heard was, remember, notice doesn't require actual notice. It requires notice under the court rules, right? And which I also believe was accomplished. And for those reasons, and the notion that there's both a pending CPS investigation of abuse and additional criminal charges pending would be sufficient to keep the ex parte order in place.
Thank you, sir. It's my understanding that the court in its original ex parte order referred the matter for a hearing in front of the FOC referee, which would have been accomplished on May 6th, but for Mr. Blumberg's objection. That has now been rescheduled to June 10th. Would your thoughts on whether or not that would be appropriate, Mr. Blumberg?
No, Judge, again, Mr. Findling probably is not aware of the fact that you also sit in the district court. So it's not like we're relying on some stranger to oversee this case. You are intimately aware of the criminal proceedings, which are about to be resolved in the district court. And you're also sitting, obviously, as the family court judge. And it's in that capacity that you issued this ex parte order. We have other concerns. The individual that's the subject of that prohibition is not in the house. He's been living elsewhere. And in spite of that, Mr. Strabling on his own has called law enforcement now on 2 occasions, alleging that he's there. And on each and every occasion, law enforcement has determined he's not there and hasn't been there. So to answer your question, and I apologize for speaking around in circles here, if we need to have this matter before the referee in June, that's what we'll do. But again, my view is that the district court's pre-trial order prohibits the individual from having contact with his own 2 almost adult children, that can also serve as protection for Axel. There has been no allegations whatsoever that there's been any wrongdoings or inappropriate behavior as to the minor child, Axel. So when we appear before the referee in June, he's going to schedule it for an evidentiary hearing, as they do, and that will put this matter off until the end of June or even July. I know your schedule is incredibly busy, but we would ask the court to schedule this for maybe an hour hearing or 2-hour hearing, just so that you can be satisfied that the order is not necessary.
Your Honor, I'm confused. Is Your Honor also the district court judge hearing the criminal case as well, or is that a different district court judge?
One-stop shopping.
One-stop shopping. I understand, Your Honor, and it's a wonderful thing about your county that you have that, and with that you have both the knowledge and experience. But I would also suggest that the threshold for an order when you sit in the capacity as a circuit court judge in entering an ex parte order is different than in a district court, even though we have the same judge. To the extent that a hearing is appropriate, of course, we're ready, willing, and able to have a hearing, on the issue. But I will also call that I was obviously recently retained on something that was otherwise an improper file.
Ms. DeFighter, can you tell me if you know how long the hearing on June 10th in front of the referee is scheduled for?
Sure. One moment, sir, and I'll look. It just says, it doesn't really say, it just says it's set for June 10th at 10:15 regarding parenting time. It doesn't say on the notice. Let's see here.
Do you have any way to look at the docket for that day to see if there's other cases right after it?
Sure, absolutely. Let's see.
Judge, if I could just chime in for a moment. Mr. Strabbing had filed on his own in pro per a motion regarding parenting time. I think that's the hearing that Mr. Five is looking at.
Oh, is it? I'm looking at
Yes.
the wrong one. Is that the one you're talking about, Your Honor, or was there a different one?
Yes,
Okay, sorry.
yes. I wanted this matter heard at the same time as that matter, because it was my understanding when I did the original order that there was a contested evidentiary hearing on the parenting time issue, and this seemed to me to be a good time to put all of it together.
Let's see. Is it 9? It looks like it looks like it's just his normal referee day. There's 3 matters set for 10:15 and then it goes to 10:30. So it looks like
All right.
it's 15 minutes, or there's like, yeah, 15 minutes. There's 3 of them at 10:15 and then the next one's at 10:30. So it looks like just a normal referee day, not a set aside
All right.
day.
All right, thank you.
You're welcome.
Mr. Blumberg, why should I go outside the normal practice of this area and not refer this case to the referee first before it comes to me?
I would respectfully suggest that this minor child has had no contact with Mr. Strabbing. Jeremiah has been the father to this child since his birth. He's 3 years old. He has a strong bond relationship with the individual, and every day that he's not in the household, it has some negative effect on the child. I know that I don't think I'm overstating the significance of the relationship. And again, I would just ask the court to take that into consideration. I understand where this puts the court. You've been presented with an ex parte motion, which has not formally been responded to. And the court probably acted under the circumstances appropriately. I'm suggesting to the court, after 42 years of practice, I've seen cases on both sides of this issue. And I think I can represent to the court that if the court were to rescind the ex parte order, this minor child would not be in danger.
Your Honor, in 2 short responses. Mr. Bloomberg has a few years on me, about 30 years, not 42 years. So I yield to Mr. Bloomberg in terms of having more experience. However, this Jeremiah fellow does not have standing, and for Mr. Bloomberg to argue that somehow there's a best interest analysis regarding a boyfriend of his client is inappropriate. This court acted under the circumstances of the 2 parties in this action and the concerns that this court had after reading the pleadings regarding the minor child. I can promise you, although Mr. Bloomberg gave an assurance, he's not giving you a guarantee that someone that is his client may or may not have done something, because I know a lawyer with 42 years of experience would never guarantee that. Otherwise, there'd be a bigger problem. Other than flying into the Otsego Lake fly-in every year, or I guess the former one, I'm not as familiar with your county as of course Mr. Bloomberg is, but of course this case should not yield an exception to anything. We have serious concerns, pending CPS investigation, a pending district court case, a no contact order. We have a child with 2 biological parents withstanding, and I don't see any reason why this should be given special treatment because of a representation by a lawyer that a non-party to this action somehow has a special bond or relationship with the minor child.
All right, thank you both. It appears to me that the ex parte order was done with the knowledge that there was an ongoing criminal case, because I am the judge for both the criminal side and the family side of these matters, or at least the potential for a criminal case. And that is still pending. So I see no reason to make a quick decision now about the propriety of the ex parte order. It was appropriate at the time. It has now been objected to by Mr. Blumberg. Mr. Blumberg is entitled to a hearing on that. I still, however, see no reason to violate the normal protocol. And if there's going to be a hearing on it, it should go before the referee first, and then come to me after that. And whether there's a bond or not with the child, a few months determination, if that's going to take that long, is what it would normally happen. I can't change that. It will be scheduled as quickly as it can be. But I still see, even assuming a bond with the subject of the ex parte order, Mr. Hibbler, even assuming that, I see no reason for the court to deviate from its normal practice. So I appreciate the arguments of both counsel. I'm not discounting the arguments of either counsel. I'm simply saying I see no reason to change normal protocol in this particular case. The matter is set before the referee for June the 10th at 10:15. I'm assuming that that will be a scheduling conference, as Mr. Blumberg has indicated. I think he's probably right. And then once it's set for an evidentiary hearing, the parties will be able to put their proofs before the referee. He'll make a decision. If there's an objection to that decision, it'll come before me on an appeal, and we'll make a decision in full at that time. So the request at this time for an immediate hearing in front of me as the judge is denied, and the case will resume in front of the referee on June 10th at 10:15. Mr. Blumberg, would you prepare that order, please?
I would, but may I ask the court a question, please?
Certainly.
Is it the court's view that at the evidentiary hearing ultimately conducted by the referee, that the individual would have the authority to rescind your order?
He can certainly make a recommendation for that. Yes, that's what the referee would do. And then it would come, that would be before me, and I would either sign it or not. And then you can object to that decision.
I'm asking because the court's aware that it is not uncommon that referees' recommendations are given immediate effect. I've never had a situation where relief was sought from a court's ex parte order. So and maybe it's an unfair question, but what's your view?
But that's why I originally wrote on the ex parte order that it was referred to the referee for a decision. So I think I've tried to be very clear, and you can certainly put it in your order now that the referee has the right to make a recommendation that the ex parte order be rescinded, and decide whether or not that should be given immediate effect. And that then comes to me for my signature. And if I grant it at that point, it'll be rescinded immediately. And if not, either side can object as they wish. So that it's my intention that the referee have the first whack at it without hindrance.
I appreciate that. Thank you.
Thank you, Your Honor. Your Honor, for abundance of clarity and for Mr. Bloomberg as well, you're going to be sending a proposed order to me versus entering it under the 7-day rule. And for that's question number 1, and then question number 2 is I don't understand the basis for empowering a referee or explaining in an order what the referee's powers are. The referee's powers are to give interim effect or not an interim effect, and we can go through the list of all the referee powers. The only thing that I could imagine why Mr. Bloomberg would want this language included was to somehow suggest to the referee that this is what the court intends the referee to do. I would merely request that the order simply restate what the court indicated, and that it's referred to a referee hearing period, on June 10th at 10:15 a.m., so that there would be no improper inferences made from additional language proposed.
Let's not fight about things that aren't in front of me before we get to them. So I've told Mr. Blumberg what I want the order to contain. Mr. Blumberg, please put that language in there. Mr. Findling, you can certainly object to that later, but I'm not going to decide things before they get to me. Mr. Blumberg, you know what you need to do. Send it in to me. Mr. Findling, if you want to object to his proposed order, you certainly can, and we'll deal with it that way. Thank you both, gentlemen. That's all.
Have a great day. Thank you, Your Honor.
Bye-bye.